The mission of the American Civil Liberties Union is to protect the U.S. Constitution and the rights it guarantees. Recently, I spoke with attorney Bill Newman, Western Massachusetts representative for the ACLU, on their concerns about the approach of the Trump administration to immigration and more.
I think it's one of the scary parts of what is happening with the Trump administration. So, for example, with regard to the Muslim travel ban, when it was first announced, and if you read the piece of paper, it clearly applies, and courts across the country have said, and it applies by its words to lawful permanent residents. Some people have lived here for their 20, 30 years, but they could not leave the country and then come back in because they were banned because of this executive order. That's what the executive order says. Now, there was a lot of pushback about that, and the White House counsel then came out and wrote a memo saying, oh no, we didn't intend this to apply to lawful permanent residents. To which the courts responded, the White House counsel actually doesn't get to change the executive order. The executive order says what it says. It applies by its own words to lawful permanent residents. And how do we know that the opinion of White House counsel won't change tomorrow? He doesn't get to overrule the president. The president says it applies to lawful permanent residents, and it's unconstitutional as applying to lawful permanent residents. It violates any number of constitutional protections. Therefore, we will not pay attention to the White House counsel's interpretation, which is not binding, but is what, according to the Trump administration, it is binding.
When that initial travel ban came out and we had a district federal court stay, then we had 3 justices from the federal appellate level also sustain that stay. They seemed, the appellate judges, it seemed to me, in their decision, kind of gave a roadmap to the administration saying, here's what's wrong with what you've said. Here's the kind of thing you can do. I should tell our viewers, as we sit here taping this, the new revised executive order on a travel ban could be coming down at any time. So with that in folks' mind, you're not contradicting yourself necessarily. We don't know exactly what might be in there or when it will come. But what's your sense of, and I guess you've to some extent already commented on this, but what the justices, the district judge, then the appellate justices saw, and what they sent back, in a way, to the White House?
Yeah, I don't think that the judges of the Ninth Circuit Court of Appeals necessarily gave a roadmap. Okay. What they did say is, here's what is unconstitutional in our judgment with regard to the travel ban, the Muslim travel ban as it's been rolled out. Interesting, there was another decision after the Ninth Circuit decision by the Federal District Court in Virginia applying just to that district, and that court took on more directly than even the Ninth Circuit the basis and the reasoning for the travel ban. And the Ninth Circuit commented on and relied to some degree on what Donald Trump saying during the campaign, which was, I'm going to impose a travel ban. We're going to keep Muslims out. Those Muslims are dangerous. They are a threat to the United States. We need to have a Muslim ban, Muslim ban, Muslim ban, Muslim ban. So that's what he said.
Yes.
And then Rudy Giuliani, who was his trusted advisor, came out and said, I was given the assignment to take that Muslim ban and write it in such a way that it won't sound like a Muslim ban, it will just be a Muslim ban, and therefore it will be legal. And the court, the district court, the most recent district court opinion says, wait a second, we really can rely on what the president said and what his chief advisor said as the reasoning and purpose of the law, which is to be an anti-Muslim, to be a Muslim ban, to in fact discriminate against Muslims. And so we have the evidence. What did they say? What was their purpose? Why did they do it? And then we can look at the ban itself, which says, oh, it doesn't apply to Christians. It just applies to Muslims from those nations. So I think that the court was very disturbed by the violation of the Establishment Clause, the First Amendment protection that protects all of us, of course, and the Equal Protection Clause and the constitutional guarantees of both free travel and free expression and the free exchange of ideas. I think the court did not say, here's what, if you do this, we will approve it. It said, here is what you've done so far that, in our opinion, clearly justifies a temporary restraining order because there's a probability of success on the merits. That is to say that the state of Washington and the state of Minnesota are going to win this case.
When we see the head of one branch of government attacking another branch of the government in that way, especially the judiciary, which is so careful generally about avoiding politics, about avoiding that kind of thought in their decisions. What's your concern? I mean, some folks have gone so far as to say we're near or we have a constitutional crisis.
It is deeply, deeply disturbing. That is, the words that the president has said, the accusations he has made are deeply disturbing. It wasn't just an attack on a decision or a disagreement with a decision. What Trump is saying is the judiciary is not legitimate. And if you listen to his spokesperson on the Sunday talk shows following that, says, the president said it, the president will be obeyed, the president is the final law, the president is the law. And that's wrong. And it's dangerous because Trump is saying, I am the law, I get to make the law, execute the law, and interpret the law, and I am the final decision making. And what he's saying with this so-called judge remark is he's delegitimizing the judiciary. Sort of saying, well, who elected him? It's the whole point, of course, is no one elected the judge. The judge is there to be an independent arbiter of the Constitution. And so delegitimizing the judiciary, particularly when a time when the Congress is impotent, makes the president the only force of the government.
Let me expand and extend maybe that a bit. Are you saying, or are you concerned that we talk about three co-equal branches of government, legislative, judicial, and executive. And it's always been wondered if at some point, I mean, generally in our system, when judiciary speaks, that's it. It's over. That's done. Do you envision a situation, or are you worried about a situation where the executive is going to say, wait a minute, we're three co-equal. Thank you very much, judges, for your decision. I don't agree. We keep going. Is that what you're worried about to some extent?
It has been the constitutional doctrine in the United States since 1803 that the judiciary has the final word on whether or not an act of the president or an act of Congress is constitutional. And the case is Marbury versus Madison, and it is a bedrock principle. Someone needs to decide. Some branch of government has the final word on what is constitutional. And since there are judges who can judge whether the president is acting constitutionally or whether the law enacted by Congress is constitutional, it's, at least in the with hindsight of history, self-evident that should be the judicial branch. We have almost never had a situation where a president has defied the court, but Donald Trump has laid the groundwork to say, I should be able to do it, because his spokespeople kind of say that. They haven't exactly said that, but there's an implication there that is troubling.
Bill Newman, Western Massachusetts representative for American Civil Liberties Union. Thank you for your perspective, sir.
Thank you very much.